Good evening and welcome to Land Title Talk, where we encourage you to text in your questions at 904-501-4481, 904-501-4481. I'm Steve Collins from, I almost said the law office of J. Russell Collins. I'm Steve Collins from Land Title of America, and I have with me my brother Rusty Collins from the law office of J. Russell Collins, affectionately known as Rusty Law. And we have Julie with us tonight to keep us all in line. Thank you for coming, Julie. And welcome, Rusty. What's going on in your world?
Oh, lots of things, but nothing exciting.
Good. So that means I get to go ahead and ask you a question.
Go ahead.
All right. So, Rusty, one thing I wanted to talk about tonight is we had a specific situation arise this week with a gentleman who owns his home. And I've already talked to you about this briefly, so I'm going to recap it for the listeners. He owns his home, and he bought it. And what I'm going to do is I'm going to change some of the facts because I don't want it to be too familiar if somebody recognizes the people involved. So to protect the people involved, to protect privacy, I'm going to change some facts about the story. But the principle of the story is going to be pure. Okay. So here are the story. Okay, not the facts, but the tweaked facts to help us get an idea what we're talking about. But we have a gentleman who bought a home 10 years ago. He bought the home with his girlfriend. Okay. His understanding was that he was the only one going on title because he was the only one that was borrowing the money. Okay. His girlfriend was also the selling agent. Okay. Fast forward 10 years, he now is needing to take the equity of the home, which is around $500,000, and he's going to he's wanting to do a refinance, and with that refinance, pay off some credit card debt. Well, he goes to his lender, and he's not using us as a title company. We got to know him by virtue of him having this problem coming to me. He wasn't a previous client of ours, so he didn't know about us. But he went to his lender. His lender used a title company, and the title company said to him, where is your girlfriend? She needs to sign. And he's like, wait a minute, my girlfriend doesn't need to sign. I'm the only one that owns the property. Well, unfortunately, that's not true. His girlfriend also owns the property. They took title as joint tenants with rights of survivorship. Okay. Well, okay, no problem. He'll go to the girlfriend. They live in the same house, but they're not a couple anymore. But they live in the same house still, and they have a child together. The child has since moved on, graduated, so they're living there by themselves. And she says, no, I'm not going to allow you to refinance this house to pay off your credit card debt. Now, he's the only one making the payments on the mortgage. So she's not making the payments. He is. What does he do in this situation?
Well, outside of doing something that would invoke the rights of survivorship clause, the only thing he really can do outside of talking very nicely and talking her into something.
Not going to happen.
What about the power of alcohol?
Not going to happen.
Okay.
I'm pretty sure he's tried all of that already.
Okay. All you can do in that situation is partition the property. Anybody who owns title with someone else that has a present interest in the title, except for a married couple, has the right to partition real property and even personal property.
Really?
Right.
So we can partition a dog?
Hey, whatever works for you.
No, seriously. You've had this issue before.
Well, dogs are just property.
Well, okay.
I don't care how much you love them, but
so how do you handle a situation where you have two people fighting over a dog?
Well, the dog is not something you can cut in half and have any use for.
Right.
Okay, so you find the value of the dog. And you sell the dog to somebody else and take the money, or somebody gets to buy somebody out.
That's interesting. Because, people are very emotional about their animals. I know we're totally getting off track here, but I didn't realize that personal property, I guess it makes sense. Personal property can also be partitioned.
Okay, but going back to real estate, it has to be a present interest.
No, don't go back to real estate yet.
Okay, darn.
I'm stuck on the dog. Sorry. So if I'm in a situation where I'm in a relationship, whatever the relationship is, and we have a family dog, I guess it's called Legally Blonde, that movie. There's that scene in the movie. Did you ever see that? Legally Blonde?
I saw the movie. I don't remember that.
The bulldog, where I wish I could remember the actress, but she goes up to him and, mumbles a bunch of legal whatever, and she takes the dog.
Reese Witherspoon.
Reese Witherspoon, yes, but who was the other actor?
Oh.
But nonetheless, the point is that what do you do when a couple, even if they're married in a divorce, let's just say they're not married to make it easy, has a dog that they both adore? It's legally under the law, that dog is
property. If you take your dog to a doggy daycare place,
right,
and a big dog gets out and eats your little dog, okay, it happened here.
Oh gosh, no, it hasn't. Please tell me it hasn't.
There was a faulty latch on something.
Really? Here in this town?
Yes, it's been quite a few years ago.
Okay.
It's back when I read it because I was at the courthouse and was able to see the documents at the courthouse before we had all that access we have now.
Okay, so it was a long time ago.
Yes, and the dog, the value of the dog is all that's available. I don't care how much you love the dog.
Yeah, but you're talking about emotional value,
all that other stuff.
I mean, you think about it.
If it's a mutt, it's worth $100.
Okay. Oh, well, that's the value that the courts may put upon.
No, that is the monetary value of the dog.
Why $100?
Well, I'm just saying, if it's a mutt,
if it's a mutt, $100.
If it's a purebred,
$2,500.
Whatever the cost.
So there's the value. They established the value. Now what?
I don't know how you're going to figure out who pays for it. I guess you could do
would you auction the dog?
Well, you could, I guess, but you get a judge involved, and after the judge stops laughing at you, they'll figure out a way to get the value and have somebody buy the dog. It's either that or put the dog down.
Well, on that topic, it was weird. I read a will.
Yeah, they want the dog, they want the animals euthanized.
Yeah, you saw that will, didn't you?
I saw that, yes.
Yeah, we have a closing where the will was basically the decedent had a will, and in the will it authorized family members to get certain things, but specifically in reference to the dog, she required that the dog be euthanized. I thought that was really disturbing.
Trying to go like a pharaoh.
I guess, but I guess it's just, to me, is just a weird thing. I wouldn't know that would even be legal under. You
don't need a reason to euthanize a dog or an animal. You just can't torture the animal. You can put the animal down. You just can't torture the animal.
And the laws don't, I guess, things I just haven't thought about.
Animals don't typically have the right to life.
Wow.
You just can't mistreat them.
Okay. To me, euthanizing a dog is mistreatment in my world.
The dog doesn't know that's going to happen to him.
I know, but still, that's just, it's just weird.
I know.
When you said that, I didn't mean to get off on this vein here, but it's just interesting to me when you think about that. That if it can be personal property, and because people do fight over animals. I mean, I've seen it.
Fight over a vehicle.
But vehicles are just they're
kind of fungible, but fungible means one vehicle's like another one. Okay, you get the same model.
Have you ever heard that word before, Julie? Fungible. Just say no.
I will just say no.
Okay, good.
I was an English major and I make them up, and I have not used that one.
Yeah, before. Fungible. Quit using words that we don't know.
Please define that in a sentence, sir.
Yeah. Fungible.
These pens are fungible.
Okay, gotcha. All right, but again, when you put animals, there's a lot of emotion involved.
Of course.
And that's just interesting. Okay, but we digress. All right, let's get back to our story.
It is.
We have what's that?
It is a word.
Yeah. Oh gosh, you looked it up. Yes. Thank you, Julie, for keeping us in line.
Sorry.
Yeah, we don't want you to get away with using words that we don't know. Yeah, that's also another movie scene. Quit using words we don't know.
Something.
Yeah. So back to the property. So they both lived there. And they both filed for homestead. It's their homestead property. It's where they live. It's where they go to bed at night. It's where their personal belongings are. So the boyfriend, who is literally pissed off.
I'd be pissed off and pissed on, I guess.
I guess. He's pissed off. And he feels tied.
He is tied.
And he feels like, I can't now use my equity. And he has no problem, by the way, with her having half the equity. He doesn't, even though he's made all the payments, for whatever reason, he believes that she's entitled. She's okay. He's okay with her getting half the equity, but he's literally very upset that she's not going to allow him at least tap into his half equity.
He picked her.
Valid point. So he can just say, screw this. I'm going to file a petition action.
He has the absolute right to do that.
And in that petition action, he comes to you, he pays you a fee. What do you do?
Make sure I charge plenty.
Okay. What's the next thing you do?
Well, okay. So in order to file a partition action, you both have to have the same interest. It must have a present interest. So
Joint tenants' rights to survivorship
that's
would be
fine, but
right.
As opposed to I'm the owner of a life estate and you're the owner of the remainder interest. There's no partition action there.
Okay, because as you as a life tenant, you have all full rights. There's no.
I have duties too, and there's other things you can do, but you have to have the same. It has to be present interest. It doesn't have to be the same interest. You can have 75%, and I can have 25%, and
Okay, well let's be ridiculous.
I can force the sale.
Let's be ridiculous then. If I have a situation where I have a person who, and this is something that has literally happened. There's 50 heirs, okay, and that number is not accurate. It could be 49, it could be 62. I don't remember the number. He bought 5% from one of the heirs.
He can force the sale.
He can force the sale, even though the estate work has not been completed.
Well, wait a minute. Do they have the fee title yet?
Well, according to you, when the person dies.
Well, I don't know. Has the personal representative left?
It's been over 2 years. It's been 30 years.
Okay, well,
it's been one of those situations where there's probably only 2 heirs, but nobody did anything, and then you end up having 50 heirs because nobody did anything. You got probate upon probate upon probate.
People had kids.
Right. So in that situation, he has 5%.
He may need to force you'd have to get to where there was a distribution, or you get an order determining an order of summary administration that gives everybody the present fee title. Now I know title transfers, but you got to have something you could.
So that's what a judge is going to require in order for that to happen.
Right.
But can that person who bought that 5% file a summary administration? He's not one of the heirs.
Anybody who has an interest. I've filed probate actions on my own behalf for somebody I'm not related to.
Okay.
Okay. I have an interest. A creditor can file an administration.
Okay.
Anybody who has an interest in the assets of the decedent.
I mean, I like admitting things. I did not know that.
Well, how many times have you had to deal with it?
Well, a lot actually, but normally we're dealing with, people who are a family member, and so I've never really ran across a situation where I'm having a person come to me and say, "Hey, file this summary administration for us," or have you file it, and we just bought this person's perceived 5% interest that they may have had. I mean, until you do summary administration, you really don't know, right?
I would make something contingent on them having the fee interest or getting it in the summary administration before I gave somebody some money.
Well, right. But my point is that they can do it. So, all right, back to this situation. I know I'm digressing from my boyfriend and girlfriend story, but I think it's important. He has 5% interest. He does a summary administration. He does it, takes care of it.
Interest. Now, here's the interesting thing. These other family members, there is a procedure in partitioning. If you and I inherit, let's say dad dies, 6 kids get the property, get a piece of property. Okay.
I wonder why you chose 6, Rusty.
It's a number I like.
Oh yeah.
Okay.
How many brothers and sisters do you have?
I have 3 brothers and 3 sisters.
Okay. Well, no, if you did an estate,
there'd be only 6
of us.
Okay.
Because Stanley
died as a child.
and had no, yes. Okay.
Okay. So if I'm saying, look, I need my piece, and you guys are like, we want to hold it. Okay.
Okay.
I can file a partition action, and it's considered what they call heirs property. There's a special provision for heirs. So I can force the sale, but what ends up happening is an appraisal. We get a value. The best way to get a value is an appraisal, or everybody agrees on it. The other heirs who are not filing the petition have the absolute right to buy me out for my proportional share based upon an appraisal.
Any one of them could.
Any of them, all of them could, whatever.
Doesn't matter.
They could take my 6 and split
But
it
that's
up.
true with any partition action. Oh, yes, it is.
No, not like that. No. I don't have the right to buy you guys out unless you guys say okay. But you can force me to sell my interest to you in an heirs partition action.
But if we don't do that, then
it gets sold.
It gets sold at the courthouse steps.
But I can't force you to sell your interest to me.
I want everybody to understand that about a partition. It's literally where a court action is filed, they determine value, and then the property is sold at the courthouse steps to the highest bidder.
No. Typically what ends up happening is we get a real estate agent.
Rusty,
Everyone I've ever done has had a real estate agent involved.
how many? I've been involved in a lot of partition actions going to the steps.
You can
Okay?
take it to the steps, but usually
If
we're gonna try
things
something
don't,
different.
yeah, well, of course. But when you don't have a willing person,
Well, then somebody's in trouble because they may not go at the steps for anything except for $1,000 or $100. Then, okay, which put up or shut up, I guess. But
well, we'll talk more about that
everyone I've
specific
ever
issue.
dealt with has been with a real estate agent. We make into a special master.
Okay.
Okay, and then we used Charlie Hilliard.
Right.
Okay, I've used him at least once, and I figured because of where the property was, I knew he could sell it, and he knows how to sell it, and we got the job done, and he was able to, because he was the special master, we got him the authority to sign all the closing documents in case one of the two parties was going to be uncooperative. So that the court can give him basically like a power of attorney to sign everything. And then it's just about the money getting to the people. See?
We had that case with the husband and wife where the wife did not want to sign off and literally gave the courts and everybody the middle finger. And the judge just gave the husband the right to sign for her.
Was this in a divorce case?
I can't remember, Rusty. It was a Volano Beach. Carla from Fidelity got involved, and you were instrumental. It was long enough time ago to where I don't know if you remember. Okay. Well, yeah. But nonetheless, I can see where that can happen. But all right. I want to get back to this 5% guy. So he's got 50 other heirs. Okay. They all own different percentages because of whatever. He files a petition action. They can't find the other people, Rusty.
Well, there are ways to get service of process, or at least legal service of process, on people you can't find.
Or don't want to be found.
Or don't
Or
want to
they're
be found.
Homeless or whatever the issue is.
There's ways to get legal service
So that
of process.
5%, he can literally go up the courthouse steps. If he's got 5% interest, it goes for...
I don't think a judge is going to let that go to the courthouse steps if that's the only person showing up.
Why?
Why? Because it's not going to be sold at market value. We want market value.
You don't know that.
We want market value.
You don't know that, though.
Well, if he...
And he is he can be one of the bidders himself, could he not?
Of course.
Right.
But the point is
if the property, Rusty, and
Well,
I think you live in the dark ages. Have you watched the auctions lately?
I've not seen the any partition auctions lately.
They're happening. Okay.
Okay.
And partition actions are subject to anything filed. So there's mortgages that's subject to the mortgages, everything. All right. Petitions or foreclosure, whatever the auction is, there's nothing sneaking by. Okay.
Well, I understand
People are not, by virtue of it being online auctioning right now, you're getting auctioneers from out of state and all kinds of things. Okay.
You can buy from the International Space Station.
That'd be cool. If you got, in this particular case, we're talking about $1 million property.
Okay.
Okay.
Well, I'm just saying.
It is not going to go for 100,000.
Okay.
Okay.
Well, good.
It's once the notice goes up and people figure out what it is, they're going to be bidding on it.
Good. Then you're going to get a good price, and then it is fair.
There is not in Florida, is anything not going to go for at least market value price, and if it goes under market value, it's not by much.
Depends on what you mean by market value, but
I mean, market
just
value is so
saying-
subjective anyhow. you know.
You could get market value from a real estate agent selling it too.
You can, but when you don't have the ability to clean the title properly. I mean, so
people are taking title subject to whatever then.
well, in the case of this guy's with the 5% interest that's got these 50 other heirs, there's not probates done on all those people. There's literally, Rusty, and I say literally, I shouldn't do that because I don't really know the exact number. There's probably 15 to 20 summary administrations that would have to be done maybe to clean it up.
But here's the thing. We turn the property into money. The
We
money
do.
Gets,
the money would go to the
gets
registry of the court.
It gets escheated to the state probably.
Eventually.
And
But it goes to
then-
the court first, and then they get notice of the sale, and they have the right to go after the money or not. And then all these, I don't know what the word is for them, those people that find money for you and they want a percentage, they'd get involved. But the guy who gets the 5% for whatever he bought it for, he could have found an heir and got it for $100.
Of course.
Could have got it for $1,000. He forces it to auction.
And takes his money and runs.
He could take 5% of $1 million, just doesn't suck.
No, it does. I mean, there's all kinds of things that happen. I don't think that happens very often like that. But the bigger thing is the boyfriend, girlfriend who decide they don't like each other anymore.
Well, no, they like each other,
Sort of.
sort of.
But you've got one person who wants
He wanted to
get
make
his
sure it was
money
clear
out.
to me he likes her. He's just very disappointed in her stance.
Well, I don't know. I mean, you can force the sale, but then he doesn't get that. He get his money, but he's not going to get to keep the property most likely.
I think he's okay with that.
Well, if he gets his money, what the heck? I mean,
But see, the issue is her. She's like, this is her home. You got to think about it. In her situation,
she can lose her home. I'm in
she
the middle of one of those.
currently, right now, she gets to live for free.
True.
And what he's threatening is to end all of that. Because if this home
But
does
see,
get sold,
wait.
they're going different ways.
I understand, but there's plenty of equity.
There's tons of equity.
And if you got
she would get her money, she's going to get half of whatever it is.
right, so she'll have money to go buy another home.
Right. She will.
Okay.
But is there, so
She made a pretty
there-
good deal.
yeah, well, no. Well, yeah, she did. But there are people who would say it's her homestead. You cannot force somebody to sell their homestead. How can you force somebody to sell their homestead? How can you force somebody out of their home? And then there was silence.
Well, okay, so I'm trying to think through this. Okay.
and, and we could
I like this.
we could thicken the plot a little bit, and we could say, and she has a minor kid. Unfortunately, that's not true. I should have just
Okay,
made
but-
that up because that would have been
All
more
right, so-
fun.
Well, but
But how about
kid
for the
doesn't matter unless somebody dies.
okay? Well, let's say we have a minor kid, but now she's going to cry to the courts. I don't want to leave. I've got a minor kid. I'm living in this house. I'm not making any payments.
Well, it's interesting because now you've got.
I don't want to live.
I hadn't thought of something a certain way.
Ooh, I like it when this happens. This commercial break brought to you by
Wait.
Stump the Chump.
Well, that's right.
J. Russell Collins, attorney at law.
I mean,
we need to
it's
take
not-
this break to figure out whether or not what I'm saying has any meat to it. But
Well, okay, so
this show is
here's the
brought to you
issue.
by Land Title of America, where we encourage you to stay local and use Land Title of America for all your real estate needs. Closings,
So-
refis, purchases, and sales. Call us at any time at 904-797-9600, 904-797-9600. Now, Rusty, I gave you a commercial break.
Okay, so
Talk.
how about this? There shall be exempt from forced sale under process of any court, and no judgment, decree, or execution shall be a lien thereon, except for the payment of taxes and assessments, obligations contracted for the purchase, improvements or repair thereof, or obligations contracted for house, field, or other labor performed on the realty on homestead.
So,
So I got to think about that. I don't
I
have
like
all this
it.
junk in my head. Okay, because here's the thing. I'm in the middle of a case in Interlaken.
okay,
Boyfriend, girlfriend.
okay,
Idiot boyfriend.
okay,
Puts his girlfriend on title with him.
okay,
They get a mortgage.
okay. Did she
He-
sign on the note?
I
Just
don't
say
even-
no to make it more fun.
I don't even care.
Just say no.
Okay. Let's put it this way. She wants her equity. Now he's remarried. He's married to somebody else and lives in the house.
Okay. With the
There
wife,
is-
I hope.
with a new wife.
Okay. And she's not there anymore.
No, she's with somebody else.
Okay. I just
they're
wondered.
not
I didn't
there.
know what's
They're
going
not-
on.
Who knows what
I
they're
mean,
with?
she's living in the back room. They're living in the front. I mean, who knows,
Stranger things have happened.
Yes.
So there's a judgment of partition,
Okay.
and
Who you represent? The boyfriend?
I represent the guy that owns the house.
That's trying to be partitioned out.
Yeah. Now,
Interesting.
I don't need much money to buy this lady out. Okay.
Okay.
But we can't seem to get a daggum loan to do it.
Okay.
We're talking about it would be a second mortgage.
Which is an interesting dilemma.
Yeah, because we got a first mortgage at
Right.
3.5%, 4%. We need a second mortgage of $30,000, and there's equity to do that,
Okay.
to buy her out for that, and like, but we have a judgment. I got to check on that because I hadn't considered that thought, and
Well,
it doesn't make sense that a judge would enter a judgment of partition that would cost the forced sale of a piece
But
of
see,
property.
I think there is a provision that allows you to force it. Well, let's talk about real estate sales. If me and my wife own a home
Mhm.
and we go under contract to sell the house,
And then you don't.
but then my wife says, "Nope, ain't doing it. I'm not selling this house. Nothing. I don't want to move. I felt like it was a good decision at the time, but I've changed my mind. I'm not selling the house. There's nothing you can make me do about it."
That's fine. We can get a judgment against you for the damages. The problem is
But can you enforce that contract and make them close?
you're supposed to be able to do it.
Rusty of old told me that you could.
Well,
Because what
under-
happens when you sign a contract?
Well, title passes in certain ways.
Okay, so how can you stop that from happening? Have we not seen cases where a person selling their primary residence changed their mind, but then a court action forced the sale of the property?
Well, I would think so. It's just a weird thing I hadn't considered, and I want to
Okay.
make sure I at least consider it because it's like, wait a minute.
I mean, we can leave this hanging, Chad, and we can just move on. You can look into it and we can talk about it next week because it's an interesting dilemma. Homestead property complicates this whole thing, in my opinion. But I still feel like there's provision of the law that allows that to happen in a partition action.
You got me. I'm like, wait a minute. I'm looking at this as a
Point, Steve
point,
Collins.
Stephen. That's fine. That's okay.
We're keeping tabs on this. So, all right. We do have a question.
What's that?
The question is, are they alive now? But I guess I'd have to figure out what that was specific in reference to.
Some are,
Yeah.
some aren't.
There were a lot of stories, but
Yeah, we were bouncing.
Sherry
back.
wanted to know if in one of the situations if she could be deemed a squatter. Does that make reference?
You're not a squatter if you own the property.
True,
Right.
but can you use it?
No.
Okay.
Not
Now,
for that.
in a case of, well, that's a very good point, Julie. And we appreciate the question. Thank you. You can text your questions at 904-501-4481, or you can actually post your questions on the 904 Now app or the our Facebook page, which is Land Side of America. And then I think you can also do that on the YouTube, but but nonetheless, thank you for your questions. So when it comes to squatters, Rusty, if you have a husband and wife situation, there's no squatters because they have marital rights, period. In the situation where it's husband and wife and they don't want to sell. Don't think that hard. That's true.
Say that again.
Homestead property.
Yes.
The title's only in the husband's name.
Oh, well, of course.
He wants to sell, but the wife doesn't want to.
Get a new wife.
Gosh.
You just get divorced.
In that case, she's off
He's
title.
disabled. He has a disability.
Okay. I know
Which
you
is
say
a-
marriage is a disability.
It is when it comes to homestead.
Okay.
It's not a bad statement. I'm just saying, being a married person with a homestead property that you own by yourself, you're disabled. You cannot mortgage, sell anything. You can't do hardly anything to the property without the joinder of your spouse.
Okay.
Okay. It doesn't give your spouse any homestead rights, but it does give them some veto power.
Okay.
The
And so
thing
the
you
only way
can
to fix
do
that is a divorce.
is unmarry them.
Yeah, because you're not going to do a partition action in that case.
There's
no way
nothing to
do it.
petition.
Yeah.
He doesn't
In
own
a
it.
husband and wife situation, you can't do a partition action, period, because, well, it's husband and wife. You get a divorce.
You have to get a divorce.
But so what we can do in this case, Rusty, and I know you're over here looking this stuff up. I'm going to get you to table it. Okay.
Oh, hey, I'm not possessed.
I can see that you're possessed. I've seen that look before. But let's go ahead and hit something that's not totally different. Almost on the same vein, a little bit. So we're talking about boyfriend and girlfriend, right? And how do we
just say no?
Just now I want to bring up a situation where, all right, we have a situation where we have a boyfriend and a girlfriend, and the boyfriend has, I don't know, let's say 4 kids, okay? And the girlfriend has 2 kids.
That's 7 kids too many.
Okay. So we got the boyfriend who has 4 kids and the girlfriend who has 2 kids. Now, the title is currently only in the name of the boyfriend. But this girlfriend has been extremely wonderful. They will not get married for some reason, for whatever reason.
Lose the benefit.
Okay, they won't do it. But the boyfriend wants to truly protect the girlfriend. They're both later in life. Okay, they're facing the twilight of their life. The girlfriend is significantly younger. How does the boyfriend protect the girlfriend? Because what happens in the case when the boyfriend dies?
How old are these kids?
They're all adults, no minor kids.
You don't have to. You can devise your homestead to somebody who's not one of your kids.
Okay.
If
As
they're
long
adults.
as there's not a minor kid.
Right.
Minor kid, all bets are off.
A minor kid, no, the bets are very short until they're no longer a minor.
Okay.
Okay.
So in the case of, let's just say he had 1 minor kid and 3 adult kids, and he dies. Then what happens?
You do what Abraham did, take that minor kid up to the top of a mountain. I love you, son, but sorry.
Somebody's got to go.
Somebody's got to go.
So what happens in that case?
A devise is not valid.
Okay, hold on.
What you do is you
Dad,
own it as
boyfriend owns the property.
Well, then
By himself, homestead property. He's got 3 kids. 4 kids. 3
4
kids
kids,
are
one's a
adult,
minor.
1 is minor. What happens to the property when he dies?
Well, they got to keep him on life support till the kid's
Okay.
18.
Answer the question.
He can't devise the property. It goes to the kid.
What about the 3 adult kids?
Well, it goes to all of them, but they
Okay.
cannot.
What does the minor kid get?
He gets his 4th.
He gets his 4th. Okay.
Right.
All right.
Okay.
Period.
If you want to beat that, the only thing you can do is own it as joint tenants. Rights to survivorship.
All right. So, but he doesn't want her to get the whole property when he dies because she has 2 kids. He wants his 4 kids to get the property too. I mean, he wants his 4 kids to get the property, and he wants his girlfriend to make sure that she's protected.
Then what you'd have to create a life estate to the kid or to the girlfriend.
I would think that would be the best way.
You can't do it with a trust. You cannot do with a trust what you can't do with a will when it comes to this stuff.
Really?
You can't use a trust to get around the certain rules. Okay. You can't use.
I mean, he could do a will, and very simply, the minor kid gets, as long as the minor kid gets the 4th. Or does that complicate things?
I don't think that's going to work. You cannot devise to anybody but the minor child is not valid. Now,
Okay.
you get the other kids, okay, they can all have their 4ths.
All right, but let's go back and say they're all adults. So we got 4 adults.
Then I don't care.
Then you could actually do in the will, if you have the will, that she gets, 1/5 interest. I mean, she could get that.
You get whatever you want.
But then she runs the risk of a partition action, doesn't she?
She could.
Because if the
That's
4
why
kids
you would do the
life estate. But you can actually do a situation where you give her a life estate along with her 1/5.
You could do that.
Right. Because without that life estate, she's now subject to the partition actions we've been talking about.
That's right.
But if she lives there, it's her homestead.
Don't matter.
But no, you're questioning yourself about that.
No,
though.
I'm not anymore.
Why?
Because
You looked it up.
I looked it up.
Oh, in that little short time you looked it up.
Yeah.
You are
I cheat.
You're Elon Musk's child.
No.
Okay. There's no way I could have done that and talk at the same time.
Well, we have to understand. My reference material has an AI component, so I can ask a question, and it uses just its own universe instead of.
So now we don't have to wait till next week.
Right. You can do it.
Okay, so the answer is?
You can partition homestead.
Wow.
Because you're not going to take away the other person's beneficial interest in the property without.
Well, yeah, you are. There's going to be consideration for it, but it's forced.
It's forced.
Yeah. And that's interesting. So what about the contract? If you sign a contract and you change your mind, it's your homestead property.
I have to look that one up too. Because
Dang,
because
that's 2 points for me today. You know that.
That's fine.
Okay.
The problem, okay, because real estate is unique, you can't always trade when there's a default like that, a breach of that contract. You cannot replace that property with money. Okay?
Say that again.
Okay. We do not allow equitable relief like a forced sale. Okay?
Mm-hmm.
Specific performance is what we're talking about.
Okay.
We do not allow specific performance unless money damages won't do it. Okay? And because real property is unique, we can force the sale because real property is unique.
Okay.
Okay? You're not going to...
On a petition action. But what about a contract?
I'm talking about a contract.
Okay, sure, talking about a contract.
Yeah.
So homestead property, they sign a contract. They decide, I don't want to sell anymore. My wife's too traumatized over this.
Yeah, but they entered into the contract, so they made the decision.
That I agree with you.
Okay, and
I agree
and
with
have
you.
To check myself on this, but the if the logic is when you sign the contract, there is an equitable title that transfers,
Right.
and all you're holding is bare legal title for the money.
Right.
Okay, so that's already happened.
I mean, contracts are powerful stuff. This is why we've talked on this show before. Yeah.
Don't enter them haphazardly.
Yeah. Well, it doesn't hurt to get an attorney. It doesn't hurt.
Especially if you're
Yeah.
buying. I think if you're selling, you need to know what you're doing. You need to make sure you're.
I think there's a place for
There's
attorneys and you know, I love my realtors and they do a great job of, you know, representing the interest of our sellers. But
the reason we let them make contracts is because that's a legal document. We let them do that, and it's not considered the unlicensed practice of law
because of the FAR bar contract. It's
they're
been approved
filling
by
in information.
Mm-hmm.
They're filling in the blanks.
Right.
Okay. The most dangerous thing they do is an addendum that's freehand.
Right.
Okay. Because I've seen it happen, and they can get themselves in trouble with unintended consequences.
And I taught classes, and if I could have $1 for every time somebody said, well, if the sellers want to get out, you know, it's their homestead property. You can't force them to sell their homestead property. And I'm like, I do believe
they already
you
signed the contract.
I get it.
Now,
I get it.
There are contingencies in contracts.
Get it. Yes.
Okay.
But if those contingencies are met, the buyer comes through, does all the notices, everything, crosses every T, dots every I, the homestead property can be sold. And so what happens in the case of a person, and I'm asking it rhetorically because I know the answer. We've actually gone through this several times where you've been the attorney. You're looking at me like you don't know what I'm talking about.
You're in the headlights.
You've done it several times.
Okay.
Okay. Primarily back in the crazy days when, you know, Flagler state lots were flying off the, you know, back in 2005 and 6. Okay. And we dealt with some attorneys that did some, you know, suit to quiet titles that forced what would the case be? Suit to quiet? No, it'd be a list pendants.
Okay.
So where they forced the sale of the property. Now this was vacant property though. This was an actual homestead property, but where people didn't want to sell. Somebody offered them more money. You know, they went under a contract for $50,000 and now somebody offered them $75,000. And like, well, I'm just going to sell to them.
You can
Yeah, and so there would be
specific performance because real estate's unique.
Right.
Even in Flagler State.
Yes, and so we've seen this happen time and time again. And even with homestead property that can happen. So interesting stuff. All right. So to protect the girlfriend, get back to that question, to keep her from being partitioned later on, because she could be forced to sell by virtue of their kids, the best thing would be to do in your mind is to do a will, right? Or ladybird deed, or enhanced life estate deed. Same thing.
If you're, you can do the transfer on death deeds. It's considered a devise. So if you have the minor,
That's still a problem.
Because it's a transfer on death.
See, I didn't.
That's
I didn't
why
think
there's
of that.
unintended
I
consequences.
didn't think about that. That actually is a scary thing because we've had people come in and ask for ladybird deeds with minor kids. And as long as they're not minors when they die, it's a moot point. But if they're minors when they die,
you got to keep them alive until the minor's no longer minors. Don't drive a car or, breathe.
okay, I got it. I got it. I mean, that's an unintended consequence that I thought by virtue of the advanced directive that it would sort of skirt by that, but I guess there's no way to skirt by that minor kid.
Look, the people who wrote these statutes
Mm-hmm.
knew we were sneaky.
Mm-hmm.
Okay, you got to be careful what you do.
Okay,
because if there's a transfer,
what if
and you have the ability,
what if there's a spouse? See, the spouse, you still have the same issue with the spouse.
How's that?
If you're married, in the situation of this girlfriend and boyfriend that I'm saying that, he cares about his girlfriend. Well, what if he's still married? Okay. And they're just estranged and don't know where she is.
Well, you don't need permission to divorce your spouse.
I get it. But sometimes people, I don't know why people don't do it. It blows my mind. And the excuse I hear all the time is, well, we don't know where they are. Well, that doesn't stop you. You can still get a divorce even if you don't know where they are.
Correct.
But they don't get the divorce. And so now they're married. They're living with a girlfriend. They want to protect the girlfriend. How do you do that? If you're still married,
keep the girlfriend away from the spouse.
And the thing is, he truly can't even sign a deed.
Cannot.
Without the spouse's joinder.
Correct.
All right. So the unintended consequences dealing with spouses and minor children are a big thing.
And again, that's why if you're going to try to do some estate planning or try to do something unique, maybe even if it's just not even unique, you need to get counsel from somebody who's an attorney who typically thinks through these things. Because, we have the guy comes in by himself without a spouse. We know he's married, and now he wants to give all of his worldly possessions to his children that aren't hers. And it doesn't matter if they were hers. He can't do that because you can't disinherit your spouse. If you do that, they get at least 30%. So there becomes an unintended consequence.
Okay. So my story of the boyfriend and girlfriend, he wants to protect his girlfriend. Protect the girlfriend. Give me the answer. We don't have a minor spouse. He's not married.
We don't have a minor spouse?
I'm sorry. We hope we don't have a minor spouse. That would be in the wrong state. We don't have a minor child. Okay. He wants to make sure that all she gets is the right to live there, but that she gets 1/5 interest.
Then you would, best way I think to do that would probably be with a trust. And I don't even like doing trust.
Now you just told me you don't want.
I don't like trust for a lot of things.
That is if there was a minor spouse.
Right. There's a minor kid.
Why not, Rusty? We know there's not a minor spouse. I mean, I keep doing that. Minor child. It's just so weird. Minor spouse. Why not just do an advanced life estate deed?
You can do a deed
because you
gives a life estate with remainder interest to somebody else.
Right. You can give her 1/5 interest and then also give her a life estate interest in that same deed.
You can. But it gets kind of weird because when she dies, her estate gets 1/5.
That's a good point.
If we want more...
Maybe just giving her a life estate.
It's very simple.
Because really what he wants more than anything is for her to have a place to live.
Right. And if she has a life estate, they can't force the sale. Now, she must do the things that a life tenant does. Okay, pay the interest on any mortgage,
right?
Pay the taxes.
I mean, the house
duties.
is free and clear.
I know, but there are duties. They must maintain the property.
If she doesn't pay the taxes, then the heirs can, or the owners can.
You can have a life estate tenancy terminated by the court.
If they're being malicious.
If they're not doing what they're supposed to do, which is maintaining.
And it doesn't mean they have to live there. They could rent it.
Doesn't say you have to live there. I mean,
they're just a life tenant. They get their ownership while they're living.
But that's why maybe a trust would be a better.
I don't know. I think actually just conveying the life estate interest, because the intentions are to give her a place to live. Period.
True, but if she wants to move, okay, or if she wants to say, I want to terminate my life estate, and I want my fifth. I mean, if you do it with a trust, see, with a trust, you have some freedoms when you don't have the prohibitions. Okay,
I disagree with you on that trust.
Well, again, everybody's different.
Beneficial interest. I mean, because that's unrecorded, and you can do a lot of stuff behind the scenes, and then you got to. Then we come back to the he said, she said stuff.
No, you have trust.
Oh,
you have a document.
Trust involves a lot of trust. And if you're dealing with situations where it's not so trustworthy, I would rather do the ladybird deed.
Ladybird deed can be canceled
by the boyfriend, which I love that right for him to be able to do that if he changes his mind.
That's
with the boyfriend and girlfriend's
and you can do that with the trust too.
Well, I don't think you have the same freedoms. I'm only giving you the counsel you've given me over the years, and that is a ladybird deed would work best in this situation.
I am a fan of ladybird deeds for almost everything. I do not like doing trusts.
Because it gives the boyfriend the right to change his mind. Right. You set up a trust.
You can still change your mind.
Yeah, it's a little more difficult. Because in a ladybird deed, yeah, that's a problem. In a ladybird deed, it's an advanced directive. So you can change your mind and just do a new deed like that without even disclosing anything to the remainderman.
And you don't have to. You don't have to tell them. You can do that with a trust too. I'm just saying, I'm not a big fan of doing trust. I don't think everybody needs a trust, okay?
Right.
But there are some times when you're doing some creative things that's going to be the cleanest way. Because if I'm the trustee and I've got the girlfriend who has a life estate through the trust, and she says, "Listen, I really want to go off, and I need some money to run." Then there might be a way to write in a conversion. Okay.
In the trust?
Yeah. I mean, there's actually tables.
I understand why, attorneys like trust, because it also funds their, high schools. I mean, their graduates, college fund, vehicles and stuff. But I think
plan.
Yeah. I think that an advanced life is, an advanced life estate deed or
this is why people need counsel for their situation.
Right.
Okay. Yeah. Again, 95% of the people come to say, "Hey, I want to trust." I tell them no. And
I know you do, and I actually appreciate it about you.
But there are times when it would be a great.
There's times I see a lot of trust, especially when it's just the homestead property. I'm like, ridiculous. Oy vey, why? Why would you do that? You have one asset, it's a homestead property. Why would you do trust?
Because somebody invited him to a dinner at the Ramada Inn and sold him a $4,000 trust package.
A piece of crap.
And nobody's read it since they got the book.
Yeah.
Okay. But there are times when you can do things creatively with a trust that you couldn't do any other way. So it depends on what you're doing. That's all.
All right. We have a question. If a city has roads plotted but the property is currently landlocked, is it a good idea to buy it?
You got a big bucket to knock down all the trees, open up the road?
Well, I'll answer that question, Ben. I think that, technically the property is not landlocked if there are platted roads but not opened. You just have the practical application of the access to those roads is a problem.
And you can't always just go open the road yourself.
Well, no, you can if you want to pay to have the roads brought up to grade.
I'm talking about
It might be cost prohibitive, but you can.
Oh yeah, you can do it. It's cost prohibitive. That's what I meant.
There's one little asterisk to that though, and that is if there's wetlands, you may have to build a bridge instead of just
or mitigate.
So it's not that easy. I'm not a big fan of buying property that is doesn't have what I call practical access. It's platted. So title insurance company, if you are buying a lot and it's lot 1, block 1 in Rusty Collins subdivision, that's fine. We're going to write you a title policy and ensure access. It doesn't mean you can get there very easily.
It's not necessarily physical access.
No,
it's legal access.
It's legal access. And so it's one of those issues that you need to be cognizant of when you're buying real estate. You can't go to the county and just say, hey, I want a building permit and I'm going to tear down the trees and build myself a driveway. They're not going to let you build a driveway for the most. I mean, we do have a few small exceptions to that's happened in the county. I don't think they do it anymore, where they're going to allow you to build a driveway through the public access to get to your property. They're going to require you to bring that road up to grade, which is a real expensive proposition. Drainage, some type of hard pan of some sort. I'm not clear on what type of hard pan, but so it's something to look out for. It's always great to have a good realtor helping you when you buy real estate so that you can address these issues and check on it. You know, I'm a big fan of the county improving these roads, and I wish there was a mechanism, because we're desperate for affordable housing, and I wish that, you know, there's a way for the county to, you know, improve these roads and do an MSBU, a municipal service benefit unit, which means they pay for the roads up front, and then over time you pay it back through your taxes. And that would be, you know, my suggestion in that situation. You know, be cautious of buying property that has a road, but it's not open.
On the newer subdivisions, the roads aren't dedicated.
Newer subdivisions not dedicated. No, it's the association that's.
And even if they're dedicated, the county's not taking over maintaining.
No, not anymore. No, that was the old days. Platted subdivision, dedicated to the public. Hey, county, Merry Christmas. Put a bow on it, and you get to maintain these now because we pay taxes. Doesn't work that way anymore.
Right.
Yeah, and actually, we have some older subdivisions where we're like, all right, these roads are never going to be opened.
We vacate them.
Vacate them. What does the county say?
Okay.
No.
No. Well.
We don't acknowledge these roads. I'm like, wait a minute. It was dedicated to the public back in the 1950s. Well, we don't want to, because if they recognize that road, now what?
Somebody may want them to
improve it. Right. So they've taken that stance, and you know, I love our county. I really do. St. Johns County is a great county, and I'm not trying to talk bad about our county, but it's not something that they would readily just say, hey, yeah, this is our road and we'll vacate it. But so it's something to be cautious of. But I know our time's running short, Rusty, but I want to talk about one last thing unless you have something else.
Keep going.
All right. Power of attorneys.
What about them?
How does it work?
You are giving somebody the authority to sign your name.
Okay. In what capacity?
As something that you can sign for yourself.
Mm-hmm.
That's fine. You cannot assign a fiduciary duty.
Be more specific.
Okay. So if I'm a trustee of a trust,
Mm-hmm.
I can't sign a power of attorney, let Steven sign for me for that trust, because that is a duty that's mine. I took on that duty. You cannot assign that.
But before you go to that, power of attorneys, why have them? What's the benefit of you? And again, I'm asking you questions just for
sure. So there's several reasons for the power of attorney. Number one, the power of attorney gives somebody the ability to sign your name to a document, and the power of attorney has to be executed with the same formality as the document that you're signing.
So if it's used for real estate transactions, we need two witnesses and a notary.
We need two witnesses and a notary.
Right. And it must have the power, if we're going to use it for deeds.
Sign or convey something.
Well,
that
not
says
to
you
sell.
sign. Well, not to just
not
sell.
to sell, because that's contract.
There must be signing a deed or conveying. Conveying means signing the deed, but if you don't use that word, you can use other words that mean the same thing.
Right.
But if it's just selling it, well, your real estate agent can probably sell it for you.
All right. So when does a power of attorney terminate?
Two reasons the power of attorney terminates. One is you go loopy and somebody gets a guardianship. Actually, here's the thing. If you have, we like our durable power of attorneys because you only have in a regular power of attorney, you only have the same ability that the principal has. So if you have a regular power of attorney, it's got two witnesses and a notary to sign deeds. Well, if you've got knocked in the head and now you're incompetent, the attorney, in fact, couldn't use it. So to prevent that problem, And when we have older people who still need to get stuff done, and maybe they have Alzheimer's or sundowning or whatever it could be, they sign a power of attorney that's durable, which means as long as nobody has filed a guardianship action
Been
and the
adjudicated
person is
incompetent.
still breathing and has a heartbeat, then that power of attorney is good. But the power of attorney expires with the principal.
So when a
until it's
principal
revoked.
dies, or if they're adjudicated incompetent.
If a guardianship case is filed.
Okay, a guardianship case has to be filed.
Right.
For that power of attorney to cease. That durable.
Right. Yeah, and here's the thing. If the guardianship that was filed was dismissed, it pops back.
Power of attorney is good again.
Right.
Okay.
But yeah, powers of attorney, but here's the thing. It's a power of attorney is not, a durable power of attorney is not a guardianship. You cannot force the principal to do something they don't want to do. They can override you.
Right.
Okay. You don't have power over the principal. It's not like you can say, hey, you have to live in this nursing home now. Okay.
That power. My favorite thing is when somebody comes to me and says, well, I have power of attorney. Now that they're dead, we want to sell their property.
Well, good for you.
Yeah.
Have you been doing CPR?
Because it's no good when you die.
Is your name Dr. Frankenstein?
Yeah.
So, yeah, it expires with the person, and there are people that don't always know that. And there's a difference between an attorney in fact and a personal representative of an estate and stuff like that.
Right. Attorney in fact is a person who's able to sign on behalf of
And
the
just
person who has power
because
of
you're
attorney.
the attorney in fact for somebody doesn't mean you can make decisions when they have if they're in a capacity as a fiduciary somewhere.
Yeah, but if you give somebody a power of attorney, you got to be dang freaking careful. You're giving them a lot of power.
You are.
If it's not specific.
So
because you can give a specific
you
power
can
of
limit
attorney
it.
and say, hey, listen, I will let you sign on behalf of me for this.
Correct.
Because there's also power of attorneys, medical power of attorneys that allow them to terminate. What's that?
Okay, we call that a healthcare surrogacy, or you could call it a medical power of attorney.
Okay.
And again, the reason we do these things is number one, like with a regular power of attorney, a durable power of attorney, with the Florida laws that changed in 2013, I think it was. The hard part about a durable power of attorney is I need to get the bank to accept my power of attorney, but I got 3 banks to go to, and I only got 1 power of attorney, and I can't get a new one because I wouldn't need the power of attorney if I could get another one signed.
Right.
So we changed the law. Number one, a copy's as good as an original. And the bank.
Is it now?
Yes. How are you going to get 5 powers of attorney if you got 5 different banks to go to? And all one on original.
Yeah, but we title people like originals to record them.
I understand that. That's fine. I agree with you.
Okay. I'm going to want an original.
You're talking about recording them. That's fine.
Okay.
That's different.
Because
I
don't want our listeners to think that we don't need originals because I need one.
But the point is the banks, they don't really care about the person's money. They just want to make sure they don't get sued. Okay. And so they are protected because of our Power of Attorney Act. All right. Same thing with doctors. We have these healthcare surrogate documents because if somebody needs to make a decision and the patient is incapacitated, then they want to be able to talk to somebody.
Right.
And somebody has the authority that protects the doctor if they say it's time to pull the plug or we want to do.
You've been given that before.
I have, and I've used it, and I watched a client die. Okay. And it was very interesting. But then.
Resty, full all around attorney. He will pull the plug on you.
That's right. Don't give me healthcare surrogacy and then get sick. Okay. I'll show up with a pillow. Put it over your face. But it's just a matter of the people that rely on these things need to be protected. That's why we have these rules. Now, the most powerful power of attorney in the world or in the United States is?
I don't know.
It doesn't need a notary.
Oh, a military power of attorney. Yeah.
Military power of attorney is the most.
Yep.
If you're active duty, it's the most powerful one in the world. There are penalties for not accepting it.
Right.
Okay. And
we want to protect our servicemen.
Right. Or in their ability to do stuff. Right. The family to do
while
stuff.
While they're serving our country.
So those are all good things.
All right. Well, this has been Land Title Talk. We appreciate you listening in. We'll be here every Wednesday. So we look forward to seeing you next week. Remember, you can always text us at 904-501-4481, 904-501-4481 with your questions. Also, you can call us at the office, 904-797-9600, 904-797-9600. And also, Rusty, how do they find you?
You call Ben, 904-829-6600.
Okay, 904-829-6600. And Julie, appreciate you being here with us as always. Appreciate your input. And we'll see you in next week. Thank you very much.